So we have 2 convicted felons out of Florida. Here's the exhibits. 497, Demarious Greene, convicted of aggravated assault with a deadly weapon. It's 497. You can write that down if you'll have it. 498, Ledbetter. Oh, attempted murder. Okay. Convicted of that. When you're a felon and you possess a firearm, that's possession of firearm by convicted felon in count 13. That's the firearm that was in their possession in the vehicle under the passenger seat. And pop quiz for you. When you possess a firearm and you're a felon, which is a felony offense, and somebody dies, felony plus death equals felony murder. And remember that party of the crime and conspiracy culpability apply too. So you'll actually see this in 2 places. Count 4 is a felony murder based on possession of firearm by convicted felon. It's got both of these felony convictions listed in it as well. And then count 13 is the standalone count. I'm almost done talking to you about the law, and I'm going to sit down. I told you I was only going to talk about the law now, and that's what I'm going to stick to that promise with you. Important legal principles, credibility and conflicts. Okay, they brought this up. Well, guess who determines the credibility of the witnesses per the judge's instructions to you? You all. Okay, there's a reason we have jury trials and not police trials or judge trials. Jury trials puts it in you're human beings. You can look at people in the eye. You can look at them on the witness stand. You can look at the evidence and corroboration, and you judge the conflicts and the credibility of witnesses. I'm going to tell you this too. There's absolutely no such thing as a conflict-free trial. And why? I'll tell you something. Something just happened there. If we now separated you and Sergeant Matt Fuller over here is going to start doing the interviews, okay? What just happened there? I saw Jesse throw down the clicker. I saw Jesse set down the clicker. I didn't see it at all. I was looking at the PowerPoint, but I heard him put it down. Y'all are liars. No, you're not. Somebody going to accuse you of lying in that situation? You're not liars, right? You're all human beings that are trying to remember things as best you're able. Maybe something that happened 3 years ago. Let me ask you, 3 years from now, what just happened with Clickergate, all right? And everybody's going to have a slightly different recollection of Clickergate. Hey, by the way, we can pull up the surveillance video too. There's the bubble right there for the courtroom, and we'll watch some videos of it too and see. We'll maybe a little bit slightly than everybody recollects. Does that mean anyone's lying? No. The judge is going to tell you, you judge the credibility and conflicts of the witnesses. Hey, let me suggest something you should look at for cell tower evidence and things like that. Those are some things we're going to be talking about in the close of my close, right? Things that show that witnesses, while human, while they might unintentionally get something wrong, there might be instances where people deliberately lie. That happens. Ain't no doubt about it. There are instances where people deliberately lie. There are also instances where people are doing their very best and should be judged on what corroboration can be shown for their human recollection. Don't confuse intent. I haven't talked about intent until now for a reason. Intent does not always mean what jurors think it does. Intent doesn't mean to cause a result. That's not what intent means, and the judge is going to tell you that. Intent is an intent to do an action, if that makes sense, okay? So intention is not more explicitly, intent doesn't mean to cause a death. Intent means to go and do an act. And if you do an act and somebody dies, okay, and that act is a felony, we call it felony murder. We also call it malice murder because of the abandoned and malignant heart and the intentional design of pulling that trigger with 6 1/4 pounds of trigger pressure. So intent does not mean anything more than it does. Hey, look, burden of proof and reasonable doubt. I would not be doing my job as a prosecutor if I didn't mention it to you. Guess who bears the burden of proof? We sit over there. We're honored to bear it. And what is that burden of proof? Beyond a reasonable doubt. They're going to try to make it sound like it's way up here, and it's not. Beyond a reasonable doubt means exactly what it says. It's a doubt for which a reason can be attributed for honest, fair-minded jurors who are honestly seeking the truth. The judge will explicitly tell you it is not guilt to a mathematical certainty. It is not guilt beyond all doubt. There's no such thing legally as guilt beyond a shadow of a doubt. Get Hollywood out your mind and start thinking about what the law is going to tell you, and the judge is going to give you that law. That's the instructions that you're going to be bound by. And that law says that reasonable doubt is not nearly as high as the defense would lead you to believe. It's a doubt based on reasonableness. And there's no reasonable doubt here. There's no doubt at all. And the last thing that I'll talk to you about before I sit down is something called the single witness rule. And the single witness rule says this: a single witness, once believed, is sufficient to establish a fact. We can try a case with one single witness without 500 pieces of exhibits, without any video at all, without any forensics, without any ballistics, and that single witness alone is sufficient to establish a fact, and the judge is going to take that. And we'll talk more on that in a moment. If that is the case, look at the overwhelming evidence the state of Georgia has brought you over the past 2 weeks. With that being the case, understand the significance and the weight of the evidence that has been presented to you here. Ladies and gentlemen, that's the law that applies to the case. It's been summarized. The judge will give you the explicit law. Hey, judge me by it, test me by it. It's going to be exactly what I told you it is. And it's that law that you're going to be bound by, and that law that shows that these defendants committed a senseless crime based on greed. They acted with malicious intent. This case is about choices, and it's those choices that they're to be judged by.
Mr. Marshall.
Thank you, Judge. Can I set that right now?
Yeah, you want me to move it?
Yeah.
Yes, sir.
Push it up. Yeah, that's good. Good morning. Good morning. Huge lecture. Mr. Evans and I do agree on a couple things from what he said. Two of the most important jury instructions that you're going to have a chance to review and read, the judge will actually send out a written copy. She's already told us she's going to do that. And I don't know the ending pages. It might be around pages 10 or 11, but you'll find it. Two of the most important concepts are parties to a crime and conspiracy. But Mr. Evans and I see it entirely different. I think it is extremely important for you to look at those, and I'm going to talk about that a little bit. I do find it a little bit interesting that at the tail end of the state's opening on a discussion of law, that the concepts of presumption of innocence and proof beyond a reasonable doubt and who bears the burden of proof is saved till last. It should be at the very front, at the top. Because Mr. Greene right there is presumed, he's cloaked with the presumption of innocence. The state's burden is to prove every element of the offense, and you'll have that set out for you in the jury instructions about what aggravated assault is, malice murder, felony murder, and it will lay out all the specific elements of the offenses. And the state has to prove the guilt for Mr. Greene separately from Mr. Ledbetter, beyond a reasonable doubt for each and every element. If you find one of those elements lacking, they have not met their burden. Also, the burden of proof is never on Mr. Greene. That's one of the things that should have been mentioned right at the start of this. State has the burden. Mr. Greene has no burden. He does not have to say anything. He does not have to present any evidence. He can sit right where he is under our Constitution and never have to do anything to prove his innocence. Now, there were a couple things, comments from Mr. Evans that I did want to go over. I believe in his PowerPoint slide on conspiracy, and this is going to be important about why you have your own jury instructions to read. I believe, Mr. Evans, I didn't object, but I believe he had a reference in there or a line about something about someone being acquitted and so forth. I think that's what he may have mentioned. There's nothing in that charge that you're going to get that says that. So regardless of what I say here or what Mr. Evans says here, go to the charge, listen to what the judge charges you with in her oral instructions after the close of all the arguments, and then go to the written instructions, which will be a written memorialization of what the judge has said, and see what conspiracy says. You won't find the word acquittal or any words like that. Another couple words that Mr. Evans significantly omitted from his definition of parties to a crime. He's correct. And this is how the court will instruct you. A person is a party to a crime only if that person, A, directly commits the crime. You got that right. B, intentionally helps in the commission of the crime. Or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Mr. Evans didn't add the word intentionally. And that's a very important component. So make sure when you go back and, well, when you listen to the instructions that the judge gives you today after arguments, listen carefully, but then refer specifically to the written instructions and not to what I say or what Mr. Evans is saying about what the law is. Conspiracy, you'll read that too, an agreement to do an act. So during all of this, I'll ask you to remember there are many incidents here that are talked about. Mr. Greene is on trial for an incident that occurred on October 7th, 2016. That is it. He's not being charged for any offenses or allegations of crime or anything in Cherokee County. He's not. Because something happened in Cherokee County, or if there was a conviction in Cherokee County, does not mean he is guilty of a crime here on October 7th, 2016. It's not the same thing. Mr. Greene is not guilty of anything because there was a gun theft in the state of Florida on October 2nd, 2016. Mr. Greene is not guilty of murder on October 7th, 2016 for an act or incident that occurred on October 15th, 2016. Those are entirely separate incidents, they're entirely separate, and you have to consider the evidence that the state has presented specifically to the crime at the Pappadeaux restaurant. So, burden of proof, presumption of innocence, those instructions are right at the start of the written instructions. You read those, it's very important. Each defendant is to be treated separately. All the evidence has to be assessed independently for Mr. Greene and for Mr. Ledbetter. It's not a package deal. Although you're looking at parties to a crime, if you think that one person is not a party to a crime, if you think that one person is not part of a conspiracy, you can find him not guilty. Now, I'll talk to you a little bit about evidence. When you look at each piece of evidence that the state's going to put up, and there are some 500, I don't know how many exhibits are done now, this entire stack. Lots of evidence here. Mr. Evans has put in a lot of different things to look at. But when you look at each piece of evidence, I want you to ask yourself, can I trust this? Or does it leave me concerned? Does it leave me uncertain? Does it leave me doubting? Does it leave me asking for something more? Any of these frames of mind, if you have, that is reasonable doubt. Unless this evidence, a piece of evidence or the collection of evidence, satisfies you in a way that you would make a decision about one of the most important decisions in your life, then it's not enough evidence. Now the state has gone and they've mixed all of this evidence into this huge bowl for you and presented it to you. I want you to take a sip of this collection of all this evidence that they have. This huge stack of photos, all of the CDs, the video evidence that you're going to review, the text messages, the cell tower data, and whatever that means, all of these packages. They want to put that up to you. They're hungry to get a conviction against my client, Mr. Ledbetter. But when you start to mix into that bowl of all that evidence, any of these issues of doubt, and any issues of credibility about witnesses like Bianca Williams, or about a letter found in a jail written by Mr. Ledbetter, that poisons what's in that bowl. It poisons the evidence that you have to see, and it poisons your ability to be able to make an independent and common sense evaluation of guilt and innocence. That evidence is tainted. It gets poisoned. This reminds me of a story. A friend would go down to his grandma's house when he was real young. Go down and loved it. His grandma would make all these great things, great stews, and soups, and breads, and all kinds of stuff when he was young. And he would go in, and one of his favorite dishes that his grandma would make was Brunswick stew. And he would go in and watch his grandma, and she would mix all kinds of things into that. She would carrots, okra, and corn, and tomatoes, and vinegar, and salt, and some chicken, and some pork. And she'd add all kinds of stuff to it. His son. And his task at the time was to basically add a little bit of salt to this mixture to make sure it tasted just right. His grandma would tell him how to do that. Well, this one time he would go back. The salt was kept in a container in a box that would be used to put into a smaller container, and it was in the kitchen pantry. And this one day he went back there and he grabbed, instead of grabbing the box of salt, he grabbed a box of rat poison. Looked granular, looked the same, and he came out. And he started to pour just a little dash into the mixture, into this great smelling Brunswick stew. And his grandma saw it and he said, "Stop, stop. What are you doing?" The young boy didn't know what he was doing. And she said, "That's rat poison." He didn't realize it. He stood back. He said, he felt horrible because his grandma had been preparing this all this time. So he said, "It's okay, Grandma, I'll try to fix it." And so he tried to stir it up. He thought if he could just stir it up, it would make the poison go away, be all right to eat. But she said, "No, son. It's all bad. It's been poisoned." When you start to add doubt into all of this evidence that they put into this bowl for you, they presented to you, when you start to look at the testimony of a known liar on the stand, Bianca Williams in this case, when you put in testimony about a letter written by a co-defendant, who I believe is manipulating his position in this case to put guilt on other people, when you put those types of things in, you poison the waters of justice. Now, you might be able to mix that up again, try to let it settle down, and maybe try to take a little sip off the top of it. No matter what you do, it's been poisoned. Now I want to go talk about a little bit of that evidence. I know Mr. Evans is going to spend most of his argument today going over all of this evidence. But I just want to be as brief as I can on some of the things. You've heard some of the cross-examination that I've had for the different witnesses. You know what I've tried to focus on. But again, as I've said, this is a trial about October 7th, 2016. Also October 15th, I'll address that separately. But let's focus on the Pappadeaux. Mr. Greene's not on trial here for Cherokee. You're not determining the guilt or innocence based on Cherokee. And you're only looking at Pappadeaux and its evidence. So in Pappadeaux, we've seen some video. And we've heard testimony about there being opinion testimony that this might be a third brake light in there, in the video. Maybe a hatchback. I don't know. You're the ones that determine what you see in the video. Not anything that any of these officers say on the stand. Not the investigators, not anything that Mr. Evans says what you're supposed to see. I can't tell you what to see. But there was no direct evidence on that video anyway. And I think the testimony given by Mr. O'Connor, Investigator O'Connor, he has no idea how many cars in that parking lot had third brake lights, how many there are in Georgia, how many in Metro Georgia, there are all kinds. Even if we give them the fact there might have been a third brake light, there's nothing tying that video to my client, Mr. Greene. Nothing. Cell tower evidence. If you sit down right after, if I didn't say anything after Investigator O'Connor's testimony, we just listened to the questioning from Mr. Evans. Boy, it sure sounds powerful, doesn't it? Sounds magical. It's so technological. You take your phone out and they always know where you are. These cell towers are basically tracking you. No, that's not the truth. And why is that important? Because they want you to believe that because a signal pinged off of a tower that was picked up, that Mr. Greene must have been right near Pappadeaux. First off, it's not a GPS thing. He's not at Pappadeaux. There's no proof of that. And there's no confirmation that Mr. Greene's cell phone, if that's the phone that they've introduced as Mr. Greene's, if that was ever in that cell region that was shown by Investigator O'Connor. Why is that important? Because I asked him questions about the range of that cell tower, for instance, if he had any documents on him about broken down or towers that were being serviced. That's extremely important, because the signal could have actually have been caught by a tower tens of miles away. We don't know. We don't have an AT&T engineer here that ever testified to tell us which tower actually should have gotten that. We don't know that. But what Mr. O'Connor and Mr. Evans want you to believe is that that phone was right there near Pappadeaux, and we just don't know that. That's reasonable doubt. And I drew that circle and talked about that area. He gave all that square mileage of where a phone could be. Unless you have proof beyond a reasonable doubt, these are the types of things you're adding together. We don't know that cell phone was anywhere near Pappadeaux on that evening. We know Bianca Williams had no testimony at all about this incident. She lied about other things. She said she didn't know about anything about the Pappadeaux. There is video from America's Best, and again, it shows an arrival time of the parties. It shows a departure time of the parties. But that in itself proves nothing. It may prove individuals were there, along with perhaps hundreds or perhaps thousands of other people that were arrested at hotels in the area. Does not prove that anybody went to Pappadeaux restaurant on that day. I'm going to run over to the Shell station. I'm going to run over to the counts that deal with October 15, 2016. So you've seen the video of the Shell station and the police officer, Officer Gallimore, in his testimony about stopping that vehicle, the Ford Focus, and the incident with Mr. Ledbetter and the shooting. In count 11, both parties are charged with aggravated assault upon a police officer. And the argument there is that the car is being used as the weapon. It's not a handgun, but the car is being used in an offensive manner that could cause serious bodily injury or possibly death. There is no proof that Mr. Greene, who wasn't driving the car, there's no testimony that he was telling or advising or encouraging his driver to go around this police car. There's no testimony that Mr. Greene had any control whatsoever over that vehicle. That is a separate count, has to be treated separately. You have to look at the evidence of what evidence there is against Mr. Ledbetter and what evidence there is and is not against Mr. Greene. I think that count is pretty easy. There's no evidence that shows that my client assisted, encouraged, aided, abetted, any of the things under parties to a crime. When you go through that definition, that he participated in any of that. Now, it's interesting, I did make a note when Mr. Evans was making a comment about the count 12, the obstruction of an officer. I think Mr. Evans, you'll recall what he said, but basically said, they focused on Mr. Ledbetter because clearly he's the one. Well, that would be my argument for clearly he's the one if you're going to find anyone guilty of the aggravated assault count. My client was not the driver of that vehicle. Those are entirely separate, and they can be dealt with pretty quickly. Now, I do want to go to the handgun that's found in the car. Again, just like listening to cell tower evidence, when you hear about a handgun being found in a car, and then you get testimony from a firearms examiner who says this gun matches the murder weapon. You just want to go sit down, right? That's it. You've got somebody up here that works for the GBI, and you just accept the word that they say. Well, that's not true. You heard my questions to the firearms examiner about any kind of additional quality control issues. That really wasn't discussed too much by Mr. Evans in his questions. They did mention this kind of purity process or two-step process. And on my cross-examination, we actually found out there was a third level, right? And actually, there's a fourth level because she didn't tell, that wasn't asked to her from Mr. Evans. So she does the initial examination. and then someone else follows up and does their examination, and they get their results. And then there's a third review, but then there's that third-party company that sets the quality control standards. And we don't really know what they are, and the witness could not say really what they are. They just send these periodic proficiency tests over to them, and then they grade them. Why is it important? Because we don't know what the error rate is. Let's say it's 10%. Let's say if in that department it's 10%. Let's say 10 out of every 100 are incorrect matchings. Well, I wouldn't want that if someone told me that, you know what, here we are at the beach, there are great white sharks in this area. I gotta let you know that 10 out of 100 times that you go in here, you're gonna be eaten by that shark. I'm not gonna go in. That percentage error rate would be too high for me. We have to know what the error rate, we don't even know what it is because there's no testimony from the party that does it, that third party company or whatever. The examiner said that she's tested 100%. Well, we don't have any records for that, and we certainly don't know how she did on this examination. And these are human beings looking through a microscope and making subjective determinations of whether something matches or does not. So that addresses just the firearms examiner and her testimony. Also, I did ask Sergeant Fuller, seated right here, some questions about his knowledge of working as a police officer and how guns are sold on the street. You'll recall the testimony, so if you don't recall it correctly from me, that's fine, but just remember what Sergeant Fuller said. These guns are sold on almost a daily basis. That gun in Florida could have traded who knows how many hands. Could have been sold on the black market, sold to friends. That could have gone through, between even October 2nd, 2016, that might have gone through 2, 3, 4 people. We don't know. The gun that was actually found or retrieved in the Ford Focus on October 15th, we don't know necessarily who had that gun beforehand. You've heard no evidence about any kind of match to a gun in Cherokee. I don't think there's been any evidence about that, matching a serial number or the gun. That could have been an entirely different weapon. I don't think we heard anything about a serial number or anything like that. So there are two elements to the gun evidence about this. Also, the other thing I do want to point out, you will have an instruction in your packet about possession. Go over that. Why is that important? It's important for the possession counts. Possession of a firearm by convicted felon. Possession of a firearm during commission of felony. Those counts, there are 2 of those counts. And also just the concept of who may have possession of anything in that car. There's actual possession. I have actual possession of something. In constructive possession, it'll be explained to you in the instructions about whether, in essence, you have control over it. One of the examples people give are, I may be in the front room and watching TV with my kids, but maybe somebody there really is the one that has power over the remote control. You know, I may have it sitting, but constructive possession, somebody else actually has real construction. They have possession over it. Those concepts of actual and constructive possession will be set forth in the jury instructions, and also whether something is sole or jointly possessed. So that's important in determining those counts. It's important in trying to determine who may have had access to that gun and who didn't. Now, I did want to go over also the investigation. You know, I asked a lot of questions and showed these exhibits of this paperwork that was found in the car. And we don't have any other independent evidence of who the prescription person is. We don't know who Jamar Musakil is. We don't have any evidence tying specifically Rashawn Brooks to the October 7, 2016 incident. We don't have any additional information on Percy Williams or the man that was in the hotel room where that other gun was found. But I think Mr. Evans' questioning during that time and follow-up was that, well, you didn't find out any information about those people, or there was no information about those individuals. Well, the reason why there's nothing for you to look at is because they never sufficiently followed up. There may have been some testimony about following up in some manner. These individuals were never interviewed. Their cell phones were never tracked. They never got cell data on those individuals. They didn't find out if those individuals had guns. They didn't find out if those people were doctors, priests, lawyers, if they were felons. They don't know anything about those individuals. They don't know if those individuals necessarily had been in that car, but I'll tell you what. You find a prescription, defendants 1, 2, and 3, a prescription from somebody in a car dated 10 days before the murder at Pappadeaux. I think as an investigator, I might want to give that to my third detective or my fourth one. Or somebody else say, hey, go do something. Go do a search on this person. Let's run some databases and find out if this person has any link to this car. That's something that's not filled in. And we're just supposed to listen to the state because they said, well, it's just not important. Because their focus the whole time was just on Mr. Greene and Mr. Ledbetter. That's all. They had closed this case with all their resources. That's what they wanted to do, and they're not going to look at anything else. A simple phone call, a couple follow-ups would have found that this individual, Jamar Musakil, had been in this car. Those pieces of paper are important. I saw them. The state didn't even have it in any of their evidence. They didn't present that in any of their exhibits. They just wanted to admit that. I want to admit that because that stuff wasn't important to them. You're going to get two of the things I know Mr. Evans will go over in detail will be, I believe, these text messages. I won't go over in detail with those. Just look at the dates, whether who you think they may have come from, which person. Look at the dates, see if they have anything to do with October 7, 2016, or October 15. The letters at Cherokee, if you determine these are from Mr. Ledbetter, then you just have to determine the source. Anything you see in those jail letters, I wouldn't believe one bit, based on who they're coming from. When I talked to you earlier about that bowl and making that stew, and that person having that made up and making sure it's pure, something good to eat, and getting poisoned, and justice being poisoned, that letter's the type of thing from someone trying to manipulate the system to put himself in a better position and to try to point to blame to other people. There are no statements from Mr. Greene in there. Nothing. His name's not on that. Those are all statements supposedly coming from Mr. Ledbetter, not Mr. Greene. I consider the source. Parties to a crime, conspiracy. My client doesn't have a good criminal history background they're showing you. They showed you a felony conviction. Okay. He's not on trial for that. And again, he's not on trial for Cherokee. I'd ask you to not be overwhelmed or think you're overwhelmed by all of this. Because all of this could have been pared down to a bare minimum. Don't be buried in this massive bowl that the state's presenting to you. I'd ask you to consider the evidence fairly, and specifically to Mr. Greene, and return not guilty verdicts on every count in the indictment. Thank you.
All right. Thank you, Mr. Marshall.
Thank you.
We would next turn to Ms. Adams, but let me just inquire of the jury. Does anybody need to take just a brief restroom break? I'm fine to do that. I see a couple of hands, so, if you don't mind, let's just we'll make it real quick though, folks. But let's take about 5 minutes and give you all an opportunity to go to the restroom. I just didn't want to have to interrupt them.
No, I appreciate that,
Um,
actually.
but let's try to make it brief, just restroom break. All right, thank you.
Jesse, can I actually close this?
Sure. It's in the red.
We need some.
Only probably because it's like high intensity, whatever in here, and I'm like, don't like just. Just want some fresh. Where is yeah, that's what I read. That's funny. Well, but it also, like, this is the big one and it's not cheap. It didn't last that long at all. And I'm very but I love it too. I like it because it like stays notes a little bit. So even if it, yeah. From 10:19 to 10:47.
That's okay. 37 minutes, okay, that's good. That wasn't
Just got one of them. Okay. Yeah, there's 2 in the restaurant.
Judge, for the court's knowledge, we had to close our laptop so they can use the podium. I need like 2 to 3 minutes when we switch out, whenever that is, to power that up and get the PowerPoint going again.
You mean now or after?
Yeah.
Adams?
After Ms. Adams. It could even be a stretch break though. It doesn't need to be leaving the court.
Don't have to send them out. Okay.
Yeah.
Judge, we're ready. I'm sorry. Bring the jury in, please. Ms. Adams, are you ready to proceed?
Yes, Your Honor. Thank you so much. Good morning, ladies and gentlemen. Thank you very much, first of all, for your patience. I know that we have been through quite a grind in the past couple of weeks, and it is difficult to continue to listen after 2 people have sat down to a third person to the exact same topic. So I really do appreciate all of your attention and your interest in this case. You have a very, very difficult decision. Okay, I don't think anyone is taking this lightly, or it doesn't appear that anyone has taken this lightly, that you, after closing arguments and after the judge reads you the law, you have to go back into a jury room with people that you barely know. I'm sure you've gotten to know a little bit of each other over the past week or so, but people you barely know, and decide the fates of 2 individuals. That's a really heavy decision. And I don't think that any one of you is going to take it lightly. And in fact, that's why out of all of those people that were here on the first couple days during jury selection, you were chosen in that little bit of time that we had to determine what individuals will sit and take this as serious as necessary. Because either one of 2 things is going to happen. You're either going to convict 2 young men of murder, the most serious offense ever, the taking of a life of another individual. That's on one hand. Or on the other hand, you're going to find 2 individuals not guilty for causing the death of this woman's husband. You're going to find them not guilty of shooting someone, of changing the trajectory of someone's life. Not to mention all of the other acts that they're charged with. That is an extremely heavy decision. And do not take that lightly when you get in there, as I know you won't. But remember, you have a choice. You have 2 options. On the verdict form, you're going to see, which is going to be a list of papers, or a bunch of sheets of papers. They're going to list each count. Count 1, count 2, count 3, And then they're even going to be further broken down between Mr. Greene and Mr. Ledbetter. And then they're going to be further broken down to say, we the jury, count one, find Mr. Greene, guilty or not guilty. We the jury find defendant Ledbetter on count one, guilty or not guilty. So just because something is said to you, or just because it seems really flashy and really easy and really like they were together, boom, 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 this happened, we're done. It's not so simple. It's not easy, and this is not going to be something that you're just going to decide in a second, but you have to give each count the attention and focus that it deserves, and you have to give each individual the attention and focus that they deserve. As I told you in my opening, just because we share the same table, and just because Mr. Marshall and I might agree as to maybe you've heard us objections, and you've heard about pretrial rulings, or you've heard about standards that we agree upon as defense attorneys, that doesn't mean that our positions are similar or the same. And in fact, I think you all are smart enough to know at this point we have very different positions and very different issues. And it's okay if you feel that Mr. Greene is guilty of causing the death of Anthony Welch, that you can convict him. But that doesn't mean that Mr. Ledbetter automatically has to come with. And I'm going to talk to you about how that can happen. And first of all, I too want to talk briefly about reasonable doubt. Again, you are going to have the benefit, which is fantastic, of all the instructions. We have pored over them, we have all had input, we have submitted them, we've had conferences about it with the judge, with the prosecutor, with Mr. Marshall, myself, Mr. Fudger. We've all gone through this. These are very carefully designed and very carefully crafted for you to take back there with you. And let me tell you about how to do this. And I don't mean to be disrespectful, it's just as I wouldn't know how to do your job. My job is to try and help you do what you are supposed to do here. Okay, so I'm not trying to belittle your intelligence or tell you something you already know, but it's very important. So you've heard all of the evidence here today, and over the couple of weeks. You've heard the court kind of intimate, and the court's going to tell you again. Opening statements, which we gave you last Wednesday, not evidence. Okay? The indictment, which you're going to have, not evidence. Closing arguments. I can tell you all day long something. He can tell you all day long something. Not evidence. You have to take what you have through all of these documents, all of the photographs, but most importantly, what came out of the witnesses' mouths. That is just as important, and that is just as heavy as any of these documents. So you're going to probably go back there and go, oh, wait, we didn't get to see that case note. It was just entered in for the record. We want to read that. No, you heard it from Sergeant Fuller's mouth. You heard it from Ms. Welch's mouth. Everyone was taking notes, and I'm going to go back over some of the important details too. But just because you don't have that document in your hand doesn't mean you disregard it. Testimony is just as important evidence. So what you're going to do is take the testimony, you're going to take all of the other exhibits and evidence, and you're going to apply it to the law. And you're going to say, what I have been given, did Mr. Ledbetter commit the offense of X, Y, or Z? Based on what we've given, does that satisfy the law? The bedrock of our jurisprudence and the trial and the basic legal system that we have is reasonable doubt. Okay, so don't let that fool you. Don't just say, oh, it's just something that we kind of think about. And I agree with Mr. Evans, and I know Mr. Marshall agrees. Reasonable doubt does not mean to mathematical certainty. There is no formula. It's not beyond all doubt. I'm not going to stand up here and say, well, it could have been an alien at that time that's on that video because it's kind of shadowy, so you're not supposed to convict. That is absolutely not true. Everybody's credibility here is at issue, so I'm not going to feed you some line just to say, oh, well, it's not clear in the video, so it can't be true. But do not discount that. Reasonable doubt is doubt for which you have a reason. You're going to see it on page 2. Well, what does that mean? That makes no sense. But the judge is going to read to you, and the law you're going to apply, and on page 2 and 3 in your instructions is going to say if your minds are wavering, if they're unsettled, if they're unsatisfied as to what exactly happened. what exactly happened, then you must find Mr. Ledbetter not guilty. And I'm going to take it even further. The judge is going to tell you, on top of reasonable doubt, you're going to get an instruction and you have to apply the law of grave suspicion. Okay? What that means is, on top of reasonable doubt, if the facts or the evidence merely place upon the defendant a grave suspicion that a charge has been or crime has been committed, or that it merely raises speculation, which is another fancy word for assumption, if it merely causes you to assume or make a leap to defendant's guilt, then you must find him not guilty. That is not enough. Grave suspicion, if you say, I really assume that that's what happened, that is not enough. You must find more. And you are going to hear about credibility. It's going to be on page 4. Credibility is super important. And as I told you in opening statements, credibility doesn't mean someone's lying. We are not saying that Mrs. Welch is lying. That is not the point. And I hope that came across. Credibility also means believability. And everyone knows human memory fails or falters or doesn't remember certain things. So the fact that she gave inconsistent statements of identification doesn't mean she's lying. It means she may be mistaken. And you have to consider that. You can't just say, oh, well, we don't think she lied. No, of course not. But you have to look at the evidence. You have to look at the prior statements, the prior descriptions. And identification is important. And I'm going to get into that with you because we've spent a lot of time. So parties to a crime, yes, we'll talk about that. But identification is absolutely important, and I'm going to tell you how and why that it factors into your decision here today. So credibility is for you to determine. You can decide that Bianca Williams is the biggest liar you've ever seen in your life. And you can disregard every single word that came out of that woman's mouth. You do not have to. You can just take it off and say, Bianca didn't even testify. That is your option. Or you can say, Bianca Williams is the most stand-up person now, and we believe everything she said, and she, came in here, and she seems really credible for whatever reason. You don't even have to give a reason. You make that decision, and no one questions you on that. That's your decision. Whether or not you believe someone or something that came out of their mouth is solely your determination. You can believe some parts of it. You can not believe other parts of it. Again, that's up to you. There's really no rules of credibility. You don't leave your common sense at the door when you go back into the jury room. While you do leave, other, if you've done any or heard anything else, or you leave, what we say, or what, you think you might have heard. Yeah, you can't focus on that. But you're all human beings. You don't leave your common sense at the door. You don't listen to Mr. Lewis. And again, I'm not saying he's lying, but you don't leave your common sense saying, well, something just didn't really add up very well. It didn't make a whole lot of sense. I'm not really sure that, that's consistent or that makes sense. So use your common sense. Think about credibility. And the judge is going to tell you, things you can use to determine credibility. You can say, oh, he's a convicted felon, we don't believe that, or, oh, they lied before, or statements inconsistent, or whatever you really find and feel is credibility, and it's yours. Again, you are going to be a body of a jury, okay? Your decision has to be what we call unanimous. You all have to come to the same conclusion as to guilt or innocence. But the judge is going to tell you, and it's going to be in your instruction, that you all have your own opinions. You all have your own beliefs. And while you are in there to deliberate together as a group, you are not to give up your belief or your position or your memory of what happened just to be congenial or to get along. And it's going to be a difficult thing because human nature, most of us are not really big on conflict. Most of us like to just get along, and most of us, and especially with strangers, most of us don't want to cause waves or anything like that. But it's going to be your duty as a juror, and the judge is going to tell you that you can't just be like, well, I guess, everybody else says, so I'm going to go along with it. She's going to tell you that you also have to listen to others, or you can listen to others. And if you are persuaded by someone else, your position, you're free to change your position, okay? But she's going to say that if you feel a specific way and you really believe that, you don't have to change your mind just to get along. We've heard a lot about prior statements, and that's going to be in the law as well that the judge is going to read you. And I know this is not the most exciting topics, but again, it's really important that we go through these. Prior statements are going to be on page 6. Prior statements are important. If there are prior inconsistent statements that were made that were inconsistent with either what was on the witness stand or what's been presented to you as evidence, that's really important to know. And I think then at this point, it's important that we're going to get into the identification. So why is identification so important? Identification is going to be on page 8, and it's going to be a question of fact for you, the jury, to decide, okay? So the state's theory, and remember, this is a theory. None of this is necessarily fact until and unless you all decide it is, okay? You're going to listen to this evidence. Their theory is what they presented to you, but you get to choose whether or not you agree with that theory and whether or not the evidence was consistent with their theory. The identification shows that of 2 individuals, if you find that Mr. Greene and Mr. Ledbetter are those 2 individuals at Pappadeaux, the evidence shows that Mr. Greene's descriptions are more consistent with the person that is holding the gun. How do you know that? You can look at the still photographs. You can listen to the description that Ms. Welch gave at the hospital. Again, we understand she was being treated for trauma. She was being in a very, very high stress situation. Not to discount that whatsoever, but you heard that actual interview. She was pretty lucid. She was able to give details such as what kind of Charmin Charlie necklace it was, how much it was, where they were standing, where the person came out from. A lot of it, and you all know, again, common sense. It wasn't like, well, I don't know, I'm trying, I'm thinking. No, it was emphatic. And it was a person that had jeans, the person had a hairline, specifics that we know from photographs that we've seen. And you'll see back there again. Of the photographs, one individual is wearing jeans, one individual is wearing shorts. You're also going to hear, or you did hear, that she gave another statement 2 days later. It was extremely consistent with the photographs of one individual, not the other. The shoes, the white shoes. You're going to see it in the video. You can see, or you did see, the white shoes. Completely inconsistent with the state's theory of what Mr. Ledbetter was wearing that day and how he was acting. You heard from Bianca Williams. Mr. Ledbetter was the only one that drove the car. Mr. Ledbetter was the only one that had a driver's license. That's the only evidence you had. Now, I'm not assuming you can't drive a car without a driver's license, but these are all the things that corroborate the way it happened. And why is that important? Well, parties to a crime exists only if you find that a person either directly committed the crime, okay, Mr. Greene, or another individual intentionally helps, advises, encourages in any way. You don't have any evidence. Bianca Williams came to the witness stand and said, nobody said anything about anything. You can be together and not be parties to a crime. And in fact, there's a law that tells you that, and the judge is going to tell you that law, and you're going to have it. Page 11, mere presence. If someone is with another individual and does not intentionally assist a vet, that you find from the evidence, okay? Not just like, well, I think he might have, not I suspect he did, I assume he did, not because Mr. Evans told you he did. These are all principles of law. Because the evidence actually showed that he intentionally assisted in any way, then there is no party to a crime. And in fact, mere presence says a jury is not authorized to find a person who is merely present at the scene guilty in that crime. You have to have more evidence of that. There's no evidence to show that two people got out, that two people planned, and even taking out planning, but that two people actually went out, did the shooting. There's no information that two people saw it, that Mr. Ledbetter saw what happened, that Mr. Ledbetter was involved in what happened. It's not that they went over even to a house specifically. There's nothing other than a car driving up to Pappadeaux, a passenger, which we all know, based on all of the evidence, was Mr. Greene, who had the gun underneath his passenger side seat that he was in a few days later at the Shell station. He got out, shot Anthony Welch, and got back in the car. You don't have any evidence further than that. Now, they want to bring in to show that they were together a few days later at the mall up in Cherokee. Yes, they were convicted of the crime in Cherokee. There's no way around that. You know that. That, again, as Mr. Marshall said, is the judge is going to tell you that doesn't mean because they did it then, they did it here. Yes, the state has proven again, very well, that they committed a crime in Cherokee. That's why Chaz Moole was here. That's why the detective was here. Okay, they've been sentenced. That's not for you to decide here. The issue here is whether or not they committed a murder. And the evidence you have to use is what has been presented to you. And again, the other acts, even though these are presented not for guilt or innocence, okay? So you have Mr. Lewis come in, you had Detective Scott come in, they still have to prove identity. So if you want to use the other acts for the reasons in which the law is going to allow you to use them, and I'm sure Mr. Evans is going to go into why you should use Cherokee, Florida, the Sunrise, in your deliberations. All right, you don't have to, first of all, okay? If you can't decide that there has been identification of Mr. Ledbetter against Mr. Lewis, you can completely disregard that, okay? You heard from Mr. Lewis a couple important things. You heard him say that the detective had called him and told him that Mr. Ledbetter, the person who had shot him, had been arrested, that he took it upon himself to start Googling photographs. And that's where he got it. And he and his wife, I think he said, started Googling photographs. He didn't know Mr. Ledbetter, but now, heck, he even knows who his mom is. So Mr. Ledbetter looks just like his mom. He's Googling this stuff. And again, I'm not saying he's lying. Please don't get me wrong. It's not about lying. He wants someone to be held accountable for him. Heck, we all want someone to be accountable for doing what they did. By the grace of God, as you heard, this is not a murder. But that doesn't mean that you just throw the first convenient body, the first person that has prior criminal convictions, the first person that's sitting at that defense table that may have the same general description. You don't just throw him out there and say, well, job done. No, they have to prove that it was Mr. Ledbetter. Identity matters in all of these other separate acts. So, Detective Scott, and I'm sorry, but we are in a murder trial, and it's going to be an attempted murder trial, can't even identify which black male is sitting at the table. And you all know it. He put on his reading glasses and then said, oh, I don't like wearing these. No, thank you, sir. That is not an acceptable answer. You don't say that, Mr. Fudger's head was in the way, so I couldn't see. No, sir, we don't accept that. We're not going to use your case to convict this man based on that. That's sloppy and that's unfair. And again, I'm not saying Detective Scott's a bad detective, but that's the evidence that was presented to you, and those are the tough decisions that you have to make, and those are the tough things you have to say. We don't accept that. That's not good enough. Mr. Lewis, we're very sorry what happened to you. It's tragic. But we're sorry. Our minds are wavering. We're unsettled. We're unsatisfied. We don't believe the identification was sufficiently proven, or we believe that the identification is tainted somehow, that you're probably, and he can say, I'm 100%, I'm exactly sure, whatever words he said. But again, it's up to you to look at the other evidence and to make the decision as to whether or not you're going to believe that, whether or not that's credible. And if you don't find it, it's like it never happened. You don't have to use that evidence. The Sunrise, Florida gun, who knows? As Mr. Marshall pointed out on cross-examination, as we all know in today's society, unfortunately, illegal guns sold on the street changes hands a million times. That's a really big issue. That's the whole, I think, crux of like the NRA and the right to bear arms issues. Illegal guns. How do we stop that? How do we stop going from person to person and on the street and selling them? It's not the law-abiding citizens necessarily that are going and buying these weapons. It's the changing hands on the street. So really, when you think about it, Sunrise, the owner of the gun, which, sorry, his name escapes me right now, the gentleman that came in yesterday, that was the lawyer, that said the gun was in his car, there was no further evidence to show who actually took that gun, where it came from, how it ended up here. Again, if you don't have identity, then you say, I don't need to if you can't figure out if that really relates here, you don't need to listen to that evidence. You don't need to use that evidence. And the fact that it's up here in a car, I'm not going to go toe-to-toe with the ballistics expert. I'm not that smart, okay? But the fact that they're saying that was the same gun, that doesn't automatically end the situation. That doesn't automatically say because it's in that car that it was in their possession a week before, or however many days at the Pappadeaux. They're at a motel where you heard from Percy Williams. This is a transient place. These are people, they're going to buy drugs. They're hanging out. And let's just be honest here. Let's call it what it is. They're in a place where people do drugs, where people have guns, where people are not, the most honest, forthright people. This is that area. That's where they are. We're not denying that. Who knows how many people had that gun? You even heard that there was a complex mixture of DNA on the gun. There's so much DNA on that gun that they can't figure out whose DNA. And you heard that testimony. We stipulated to that. We agreed to that. Who knows how many people had that gun? So again, the evidence, you cannot make the assumption. You can't make that leap. You can't speculate. You can't conjecture that that's what happened. And if you don't believe me, these aren't my rules. These aren't Mr. Ledbetter's rules. These aren't criminals' rules. These aren't, a technicality or a loophole. I'm not trying to pull one over on you. This is the law that is written that you have to decide. And you have to take into consideration, because as much as protecting the community is important, we also need to protect those people that are charged with crimes to get it as right as we possibly can. Mr. Evans talks a lot about you hang with criminals, you do things. Well, we didn't tell you about on page 12, there's also something called mere association. And you're going to have that in here as well, too. You can't find someone guilty who merely associates with other persons involved in the commission of a crime. And again, you can read this. So it's not as simple as, you two come together and you're associating together. Mr. Marshall and I, we're defense attorneys. We're sitting at the same table. We come in here together. We're talking. He's talking. I slip down and steal your pocketbook. We walk out together. That doesn't mean that we're parties to a crime. You got to show that Mr. Marshall actually had knowledge, helped, assisted somehow, and not just assume it. It has to come from that table. That's the whole point of protecting those that did not have intention, did not have knowledge, did not plan. You hear the hanging with the wrong crowd. Well, we dismiss it so much nowadays. But there actually is a legal basis for that. You can hang with the wrong crowd and be not guilty. You can associate with the wrong person and not be guilty. And again, it's for you to decide based on the evidence. How do you know that Mr. Greene, again, is the shooter? You're going to hear, or you did hear, and you're going to have those text messages back there. The thing we made such a big deal about Debo and whose handsets. Text messages in there, and you'll be able to read them that say, hey, I just laid somebody down. That's Debo sending a text message. You want to buy an iPhone? That's not, hey, we did this together. Hey, we're in it together. No, that's Debo sending to what the states believe, text message to Mr. Ledbetter. Hey, I laid somebody down. You want to buy this stuff? Mr. Greene doesn't need anybody to aid or assist or abet. He's able to commit these crimes on his own, and does commit these crimes on his own. You're going to hear about the letter, okay? And you'll have the letter back with you, and I'm sure, Mr. Evans, I know that a lot of you, saw the letter as it was displayed for many witnesses and sat there right in front of you, so you'll be able to read it, okay? There's some issues with that letter. First of all, let's not forget, everyone wants to say, oh, well, Mr. Ledbetter wrote that. Let's not forget, it was in Mr. Greene's cell, and the state's theory is that it's in a cell in a completely different correction facility, in a different jail, okay, in a different county. Mr. Ledbetter's not even in that jail. You heard the officer from Cherokee come up and say that that's actual contraband. Okay, letters from other inmates, there's contraband. So it's equivalent to a weapon, drugs, and they go through. So presumably, first of all, we'll talk about the envelope in a second, but presumably, if there's someone reading and going through mail contraband, then do you really believe that a letter, a confession, a co-conspirator's statement that says, hey, we did this together, we did this, and all the details of what we're going to say, what we're going to do, and how to get out of it, you really think, first of all, that would have passed through the jail screeners, okay, who go through to look for contraband and read these letters, go through, look for drugs, go through, look for weapons, and then they're just going to nicely deliver it to Mr. Greene. Here's your mail, sir. You really believe that that really happened? You really believe there's no envelope? Well, that's interesting. There's nothing further to show where it came from. There's certainly no signatures. There's no handwriting analysis. There's nothing in there. Those are all questions that you have. And I don't have to answer those for you. Mr. Ledbetter doesn't have to get up in front of you and say, oh, you know what happened? It was Mr. Greene's cellmate that, they wrote this together. Or, oh, you know what happened? This was Mr. Greene's mom wrote it in an attempt to help. Or, this was Mr. Ledbetter's friend or something. No. I don't have to say that. And then again, I'm not trying to pull the wool over your eyes. And I'm not trying to say we don't have to show that to you. Absolutely not. But what I am saying to you is that is a consideration that you have to think about. And you just have to go, well, I don't really know what happened. Okay, that's a doubt. And you don't consider it. You go, I don't know how it got there. Yeah, that doesn't make sense. Yeah, that doesn't seem right that two secure facilities. If it came out of the Cobb County Jail, okay, and then went into the Cherokee County Jail, 2 secured facilities let contraband out and in and delivered directly to him. Is that really believable? And if it's not, you don't have to search and go, well, how did that happen? You can just say, no, I don't know about that. It doesn't seem right. I don't feel confident in that evidence. I don't feel confident that that's evidence that's going to, again, be used to convict a man for the most heinous crime that we have. Mr. Evans mentioned something about the charges, about you hear about people are charged, all 5 people on a crime, and how does that matter? Remember, charge does not mean conviction. Plenty of people, as I know you all know, are charged and not convicted. Convicted means found guilty. for many, many reasons. Some people charges are dismissed, some people charges are reduced, or some people resolve it in other ways, and some people have to go to jury trial to present everything to y'all and then have y'all make a determination that they're not guilty. So just remember that. Just because they're charged does not mean that they are guilty. Now, I just want to briefly, and I'll wrap up here, but I do want to just go over a couple parts of the indictment to give my 2 cents, okay, and just things for you to consider. Again, just because you find Mr. Greene committed these offenses does not mean that you drag Mr. Ledbetter with him. Just because there are 4 counts of different types of murder doesn't make it 4 times worse. You don't look at it and go, whoa, this must be really bad. No, you look at each one individually and you say, okay, the law does allow the crime of murder to be charged in many different ways. That's true. But again, don't be overwhelmed by the mere substance of this indictment. It's a long indictment. Okay? But if you don't find that the evidence shows Mr. Ledbetter intentionally committed a murder and involved intentionally and knowingly participated in a murder, it's not guilty. And it's not guilty if you do not feel that he committed this crime intentionally. It's not guilty then on felony murder. Mr. Greene could have been in an aggravated assault. Mr. Ledbetter is a convicted felon. Doesn't mean he committed a murder. So if you look at count, 4, it says felony murder because Mr. Ledbetter is convicted of attempted murder. Yeah, it's in there, okay? But it doesn't mean that he committed a murder. He can be a convicted attempted murderer, but it doesn't mean that he did it here. And it doesn't mean that just because you have that conviction that you automatically make a leap to murder. You still have to find that he knowingly, intentionally, party to a crime, all of those buzzwords which you will have apply. Aggravated assault, same thing. Possession of firearms during the commission of a felony. Again, yes, I mean, there are different ways to possess, okay? I'm not gonna shade it or color it. It doesn't mean that, he has to actually be holding the gun. But again, if he's not involved in this, he's not possessing it. Because you saw that gun wedged down in that car underneath Mr. Greene's seat. It wasn't just sitting on the dashboard. I mean, that would be silly then if I'm standing up here being like, it wasn't like in between on the center console. It was wedged deep down that I think he said he almost missed it because it was so wedged down underneath the seat. That's not knowingly. Just because he's driving the car, okay, it doesn't mean that he knows everything's in the car, and they're not going to tell you that either. That's not the law in this situation. The obstruction, you heard, first of all, I want to make clear that the obstruction is only against C.J. Wagner. It is not against Officer Gallimore that was hit. Okay, so you're going to hear, I think that Mr. Evans is probably going to make, or at least touch upon, that there was a felony stop and that they were in the commission. Well, it's not charged with obstructing the first officer. Okay, so when they blue light, there's no obstruction that's charged at that point. The obstruction is for later with Wagner, which you saw pictures and you saw the video where Wagner, unmarked, plain-clothed, and I know he came in here and said that we were about this far apart. Now you saw the video. I mean, they were some ways apart. So he screamed, stop, and Mr. Ledbetter, again, and he testified, he was coming at me. They were bailing out of the car. Again, common sense. We went through what direction he was standing in, where he was. He's like, ways down. They're running around the car. Let's not make more of this than what it really is. Let's use our common sense. Let's use the evidence to say, no, I'm sorry, Mr. Wagner, Detective Wagner. We don't believe that Mr. Ledbetter was coming at you. Okay? he was probably bailing out. And I'm not making any assumptions or any argument as to anything having to do with the way the police reacted. I'm just saying he jumped out, he's bailing, he's trying to run. Okay? He's trying to get out of the car. Officer Gilmore said we fully expected that to happen from the get-go. And the last thing I'll ask you to notice is on the video for the aggravated assault with the car, you were able to see, you have the benefit of being here and being able to review everything, okay? When they're out in the scene, obviously this is all chaotic and all happening really quickly, so they don't have the benefit of sitting and analyzing all the evidence. But you were able to see, the tight corridors, the way the car was boxed in. You even were able to see the video of trying to get around and the officer actually kind of stepping in front. That was on the video. It's not a situation where Mr. Ledbetter is trying to mow this officer down. I just want to point out to you that and to consider that in your deliberations. There's a lot of information here, and there's a lot of evidence here, and I would just ask that you do your job, as I know you will, and at the end of the day, when you review, when you really focus on what's in front of you, what's been presented, and what is credible, and what is not credible or incredible, that you will return a verdict of not guilty against Mr. Ledbetter. Thank you very much.
Ms. Rhodes, did you need to, you said you needed to switch something out?
I do, Judge.
All right, and ladies and gentlemen, while they're getting some of the equipment straight, I'm not going to send y'all out, but certainly if you'd like to stand up and just stretch your legs or get some water or something like that, you're welcome to do that. Ms. Price, is there plenty of water in the picture there? I think there is. It's pretty fresh.
Just stay. Nope, I'm good.
I'm ready, Judge.
Oh, all right.
Are you all ready?
All right, Mr. Evans, you may proceed.
Thank you. So as I told you, this is going to be my last opportunity to speak. I'll break up my closing argument into 3 points. I want to respond, first of all, to some of the things that the defense has said to you. I want to briefly give you some important points from the state's case. Y'all have been paying close attention to it, so the good news is we're not going to go through 500 exhibits right now. You'll have an opportunity to do that when you get back to the jury room, with some exceptions that I might talk to you about, such as videos. That has to be watched in the courtroom. So if you needed to see a video again, that's why we played it 2 or 3 times for you when we play those things, because the videos don't go back with you. They'll be here, so I wanted to mention that to you. And then I want to give you some final thoughts before we get to the important part of it, which is the judge giving you the legal instructions, and then you finally going into your deliberations. So those final thoughts are some things that I would ask you to think about in terms of your responsibility in the case. Bless you, Judge. So the first thing I want to talk about is the defense, and it started with some things that I noted from opening statement from Mr. Greene. The first thing was there's no video of my client. To the contrary, you've seen lots of videos of Mr. Greene, haven't you? The America's Best, before and after the murder. You saw some very grainy video of Pappadeaux and Pappadeaux. That is defendant Greene. There's no link to the firearm. That man over there was caught in the very vehicle where the murder weapon was recovered under the seat that he was sitting in. That in and of itself is about as close to the link to the firearm as you're ever going to get. Show it Greene's phone. I'll take that dare. It's in his car, by his seat, with his selfies, State's Exhibit 168. His picture, Devo, hey, extracted from that SIM card from an otherwise erased phone. We got other phones linked to it with phone calls and text messages, and of course the other circumstances as well of them being together. Don't leave your common sense in the courtroom. I would give you that same advice too. All right? He may have put that phone in the name of Heartbreak Kid. That's Heartbreak Kid sitting right over there. Devo, Greene. And we've shown him. No identification of Greene. Well, the video, the cell towers, his arrest, all the other facts and circumstances showed precisely who's involved in this case. And those two people are sitting over there, Greene and Ledbetter. What about some of the things Ledbetter said in opening? He's not the individual who committed the crime. Well, we can just take a pause there and go back to what I said when we're talking about the law, right? You don't have to determine who the individual who actually pulled that trigger is. Why? If I gave you that pop quiz right now, the very two terms, I hope that you said part of the crime and conspiracy culpability, right? I don't have to show you who the individual is. You know, thank the Lord that that woman lived. Do you know how many double homicides we have where we don't have a person to come in to be able to point the finger at somebody and say that's the one that did it? Happens all the time. Happens all the time. Inconsistencies, you know, I would make the worst, I've said this to my staff and police officers, I would make the worst eyewitness. I kind of know faces and stuff, but man, whether you got a blue sweatshirt on or a black, those kind of things are just, I'm not good at it. That's not me. But there is far more that she was consistent about than what she was inconsistent on, right? Far more consistencies and inconsistencies for a woman who went through the most traumatic event that you could ever imagine in your life. And understand this too. These defendants were charged before I asked that question last week. Do you see the man that did this in the courtroom? And that man, Sergeant Fuller, was correct when he said, I was going to charge him whether she picked somebody out or not. Our case does not rise or fall on whether Cynthia was able to make that ID or not. But I wouldn't be doing my job. I don't want you all going back and holding it against me because I didn't ask the question. She was emphatic. She got a good look at the person who did it. She pointed her finger and she said Ledbetter was the person that shot me. That's the evidence before you. But you don't have to decide that. And our case doesn't rise and fall with Cynthia Welch and her identification here. I'm going to do my responsibility and ask the questions because that's what we as prosecutors must do. So that you don't hold it against the state for our failure to do so. But there's no doubt who murdered her husband and shot her. It's those men over them. They did that. The key operative word being the they, the parties to the crime, those conspirators. Sufficiency and forensics. I told you this wasn't a forensics case. There's actually some pretty good forensics that you had here. The geolocation stuff is actually, I find fascinating. It's modern day law enforcement, as we'll talk about in a minute. There was a complex mixture of DNA on that firearm. When we get more than 3 profiles, you have enough alleles, is what they call it, where it's you can't say one or another. Sometimes when you have only 2, but when you have more, you'll see the report says you got 4 individuals. Okay, that could be the person who sold the gun. It could be the guy that bought the gun. It could be 2 defendants that passed the gun around to each other. It could be anyone. So it's sort of a wash, but this is not really a forensics case. They wanted to poke holes at the hospital interview. One of the most heart-wrenching interviews to listen to when you know the fact that that woman's husband was just murdered in front of her. I don't remember what I said at the hospital. Did you hear the difference between her statements in that recording versus how she testified before you? You can tell she was medicated, a little bit out of it, and doing her very, very best to help law enforcement figure out and identify who did this to her and her husband, and credit to law enforcement for being able to do so. What about Bianca? This is the part that always kind of cracks me up in cases like this. You know, she is not the state's friend. She was prosecuted by the state. My peers, my fellow prosecutors in Cherokee County prosecuted her. She spent, 2 years in jail, and then I go to probation. Good. Honestly, maybe more would be appropriate. You know, I'm not second guessing Cherokee, but I'm not sure that in Cobb would have been that light. You know what I'm saying? Look, she is not a friend of the state. Guess whose friend she is? Think about that. That's their friend. It's Ledbetter's girlfriend. These buddies over here, this is the part that cracks me up about this whole fictional thing that we do. They're all thick as thieves until you get to the courtroom. Everybody's thick as thieves when you're out running and gunning. And all that changes when you get to the courtroom because it's every man for himself. And everybody starts pointing fingers and just saying just how horrible everybody else is. Yeah, be careful who you run with. Indeed. The thing about it is we never, from the state's perspective, just take people at their word at face value. We're always looking for the corroboration. Cell phones, video, ballistics, right? All the other things that we can look at that corroborate what people say. Bianca said, well, Ledbetter controlled me. Yet she came here and testified against him. It's the second time she did so. She did it in Cherokee as well, right? Trying to suggest that he's so controlling of her. Well, it tends to prove her credibility that she would take that very difficult step of getting away from him, getting out of that control, and now testifying against somebody that she was in a relationship with. What about these other names and other stuff on paperwork? Man, so what? So what? There are other names and other paperwork that were found in this Ford Focus. Everybody clear on that? Are we about done with the other names? Look, my car is pretty clean. I'm like an OCD kind of person. If you went and searched my car now, you're probably going to find a receipt from Kristen Birch. You don't know who that person is. She's a victim witness advocate sitting on the front row, part of my staff. We go to lunch and we talk about cases and things like that, as does Nick O'Connor, right? You're probably going to find somebody else's name on a piece of paper. That doesn't mean that they are with me when I do some sinister crime. That's not evidence. That's not evidence at all. I mean, you saw how dirty this car was. It was nothing like my car. I mean, there's a lot of stuff in there. There's a lot of stuff in there. And this rental car that was passed due back in Florida in September of 2016. There were probably a lot of people at different times that were in that car. But this is the best part about it. You got the America's Best video of only two people getting in that car and getting out of it. Only two people getting in and out of that car before and after the murder. They were seated over there. That's them. That is a little sleight of hand. That is an attempt to distract you from the evidence. And your duty is to evaluate the case on evidence presented before you, not speculation. You're more like the scales of justice, right? You look at the evidence that's presented on the scale and don't start speculating, guessing, thinking about, well, how did that get there? Okay, the evidence is what comes from the witness stand presented before you and these exhibits that go out with you. It's not what an attorney says. It's not a question. Questions that attorneys pose are not evidence. Okay, the evidence comes from the witness stand, and this is just smokescreen. Smokescreen. It's like saying the state only brought you 500 pieces of evidence. They needed 501. We brought you 501. They say 502. Right? They're always constantly raising the bar, trying to suggest that it's something that it's not. Omitted intentionally, I respectfully disagree. I talked about intent. I specifically talked about intent, what it meant, intending to do an act versus not intending to do an act. So I disagree with that. So what's the difference between aggravated assault on a police officer and why Mr. Greene said I'm not guilty of that? Here's the easiest way to think of party of the crime and conspiracy. Look at Percy versus Greene. Remember Percy? The difference between sprinting from a car as a party to a crime and I don't know what is going on is the difference between party to the crime and conspiracy culpability. Do you see that? Do you see the difference there? That's somebody that's merely present or merely associated. Somebody who happens to be there. Not somebody that's actively involved in a crime spree like Greene. Percentages of error. Again, this gets back to questions and what's evidence and what's not. The questions of trying to make like percentage of error, it's pass fail. You got to pass it or you did. You got it right or you did. Right? And as much as you might want to ask the questions and make it seem like it's something different than that, I'll tell you what, I'll take the percentage that actually is evidence because it has to come from a witness's mouth, not a lawyer's question, 100%. That is evidence. That is evidence, and that is before you, and that can be considered, not the questions. Percy versus Ledbetter is a good example of the difference between mere presence and mere association. I think you all can kind of see that now. All right? I think hopefully you can see that now. The difference between it is whether you're actively in a role or you just happen to be somewhere. So let's get to the state's case. This is part 2. Our evidence actually starts in Broward County, Florida, as you know. Clark Parker, Sunrise, Kurt Lewis, Hurricane Matthew. This was no longer a safe place for these defendants to be on many levels. And the cell towers show us that they were in Florida at the beginning of this. The text messages confirm that as well because Greene actually says his address. Come pick me up, right? And you see that they're in Florida. So what do we know about this? Well, on August the 21st, this other act's evidence, Mr. Ledbetter tried to kill somebody with a handgun in just as about a senseless manner as what happened at Pappadeaux. And on the very next day, going into the morning hours, by August the 22nd, there was an arrest warrant for him and a SWAT team hitting a house where he was known to be. Remember hearing that evidence? This is all while Kurt Lewis was what? In a coma. This is before he could even be asked, can you ID the person? This arrest warrant was taken before anyone could talk to him. He was identified within 24 hours as the person who did it. Oh, and by the way, Kurt came into the courtroom and said, I was face-to-face with him, and that's the dude over there. Not only that, I did my own homework, and I found some Facebook. We're great. We're doubling, tripling up on the identification. It has nothing to do with the detective who made a mistake, who honestly didn't intentionally. Like I said, I would be probably a terrible witness. I don't think we can fault the detective. He actually identified Mr. Ledbetter very quickly by August the 22nd of 2016, 3 years ago, and was able to get enough evidence to charge him then. So before leaving, they needed a new weapon. Clark Parker, same county, by the way, all Broward. Like we're all still in Broward. This is their playground. But with Hurricane Matthew bearing down and the Broward County Sheriff's Office bearing down on Ledbetter, it's time to find a new playground. And our cell towers and our geolocation information paint a beautiful picture. This cell tower technology is fascinating stuff. This is modern day law enforcement that you're looking at here. And the text messages tell us some things too. You can actually see them talking about stuff as you look at those that are of great assistance to us as we look at this case. So, by October the 7th of 2016, we know that the defendants are at America's Best where Bianca checks in. You saw the video of that. You saw some photos of that as well. And they're at Pappadeaux, just the two of them. After they leave, the only two, go to the car. Right? You have to do the time adjustment about 30 minutes and 50 seconds. There are only two leaving in the car. Just before this murder that happened here at a restaurant where two loved ones went out just to celebrate. A night of celebration. Woman's 49th birthday, 20 some odd years with her husband. Bam. Bam. 2 instants and everything changed. Two instants, everything changed. A loving meal together relegated to this mess, a parking lot. As that woman bled and fled, looking for help for her husband, who lay dying in that parking lot. This bowl that we have behind us, this poison, this is not the state's poison, it's their poison. They did this. They brought these ingredients together, and we collected it to show you. Well, we didn't add a single ingredient to this. We brought it to you to show you what these men did under the cover of darkness, out of greed, out of malice, and by choice. And then, by October the 7th of 2016, nonchalantly, watch their demeanor. This is 3 minutes after the murder. 3 minutes after the murder, that forward focus. Backing in with that third tail light. You'll notice it best when they take the foot off the brake. There you go. Illuminated, see that? Foot off the brake, all three will go out. Boom. And in the panic of what they did, look how calm they are. One's playing on his cell phone. Nonchalant. You want to talk about malice? You're looking at it right there. There they are, 2 killers caught on video before and after the murder. And the cell tower evidence confirms it. You know, you don't have to take our word for it. You can look at this stuff. This is beautiful, isn't it? This is modern day law enforcement at its finest. This could be Greene's cell tower hit for the SMS message. And right here, y'all know what this place is. How many times have you seen this aerial, right? This is modern day law enforcement at its finest. Cell tower geolocation analysis confirming what the video already shows and what we already know, that these 2 men are the Pappadeaux murderers. So, case is going a little cold. Then October 11th, 2016 rolls around and we got our break. An important break. Knowing that these things were likely related, you have these defendants perpetrating what? Another armed robbery of jewelry at gunpoint in the same vehicle. And fortunately for us, thanks to our law enforcement partners in Woodstock and Cherokee County, a side of the lead that we could use to solve this. By the way, just step back objectively for a second here. Okay, we suspect that this is involved in the Pappadeaux, right? It's not happenstance that we find the murder weapon in that vehicle later. You want to talk about common sense? It's not happenstance. It's not an accident that murder weapon turns out in the exact vehicle that these guys were looking for. So sometimes you just got to step back and say, well, what are we dealing with here? We got 2 defendants caught in the car with the murder weapon days after. Do we really need to go much further than that when I told you the single witness rule? But this is what defendants do. They come to court and say it's not enough, and we're going to do our job and say, fine then, dare us. You tell me it's not enough, we'll bring you more. By October the 15th of 2016, law enforcement were doing some pretty good police work. Whatever happens at the end of this case, sincerely hope that y'all will go back and have some pride in the police work that's done here in Cobb County. And in our neighboring counties as well. Some pretty good police work here, piecing things together. These guys don't give up. We don't give up. The state doesn't give up. These people deserve more than that. The Welches deserve more than that. And we're not going to give up. Bianca checked into the Red Roof Inn. And we start working CIs, something we have to do. We have surveillance at the Red Roof Inn with defendant Greene. Let's talk party to the crime. We're going to talk to the active participant wearing Chaz Mole's necklace and the earbuds. See that? Wearing that before before he ditches it. And there it is, the Ford Focus confirmed by C.J. Wagner. This is good police work. This is a no holds barred. We're all going to be all hands on deck. Let's find the people that did this. Which culminates in what happened at the Shell gas station, our last 3 counts. And here, defendants pull up, and but for the grace of God, we've got 2 police officers that are still alive. As Ledbetter rounded this vehicle and tried to run over Officer Gallimore, who's trying to protect the citizens of Cobb County, forcing them to shoot at this vehicle to make sure nobody else suffered like the Welches did. Strikes the Nissan, damages the back quarter panel, hits the curb, front left tires badly damaged. They both bolt. Percy, not a party to a crime, merely present, freezes. That's the difference legally between a witness and a defendant. You see that? That's the difference between defendants, murderers, and a mere witness. The conspirators flee. The conspirators take off into the night. Don't make it very far, though. This is the vehicle. It's hard to see here. It's dark. This is where C.J. Wagner would have been parked. I used this one because you can see the evidence placards where the 4 shell casings were located after he was forced to open fire on Ledbetter as he advanced toward him despite his command. That's your obstruction count on Ledbetter. And dropped him here at the front of the vehicle just for confirmation that it is just as C.J. said it was. But look where the location is. It's not beside the car. It's in front of the car. He made it that far. And here goes Greene. Saw it on video. Remember the multiple angles, right? And back here is the key card. He probably dropped that key card right back here. It's for a hotel key card. And he rounds the corner. And he's hauling. I mean, he's flying. And right there where Officer Rainwater found it, right? He gets right by those bushes. And did you see him? He's taking, as he rounds the corner, you can see his hands go up. You got to get rid of that necklace, right? Got to get rid of Chaz Mole's necklace because that's part of his spree. That's a party to a crime. That's a co-conspirator. Makes it this far by the bushes. And there it is. There it is. And you can see him on the video right there. There it is. Nice try. We got you that Red Roof Inn. We got your geolocation information. And now we have the Ford Focus. And while it was rented by Bianca in September from Florida, it's got Ledbetter's ID in it, both linked to the vehicle, 2 cell phones, 2 cell phones for 2 defendants that have now been linked to these guys in 1 murder weapon. The text message helped us out too, right? You can look at the text messages, you can actually see Greene sending his address, all right? You saw that. And they're actually talking about other robberies as well. So you'll have State's Exhibit 167 back with you. And you'll see that there's all kinds of discussions about different things. And here's Greene on October 1st saying, here's my address, October 1st, 4920 22nd Street. You'll see on the next day, they're talking about dropping somebody, getting a chain and an iPhone. You want to buy a chain and an iPhone? And hitting licks. It's on October the 6th. By this time they're in Georgia, right? On the 6th, they're already talking about hitting a lick. It's Cynthia and Anthony were a victim. And that geolocation analysis corroborates what we know. We can show that they were in Florida. We can show they came to Georgia. By the way, we can show they went down to Florida again. Remember that? Bianca told us that? All right, well, let's test her. Let's test her. Can you show me, did they go back to Florida? Absolutely they did. Geolocation analysis shows us that. And it also shows us they came back to Georgia too. Better than that, we have the cell phones themselves are actually recovered from the Ford Focus, the instrumentality of this murder in Pappadeaux, the instrumentality of the armed robbery in Cherokee County, and the instrumentality of the aggravated assault on Officer Gallimore. So with these two cell phones, we find the .380 murder weapon. Here it is. This is it. The instrument of death that these men possessed, that these men had, that these men used out of senseless greed, with malice, and by choice. And we know scientifically it to be the murder weapon because we sent it for ballistics analysis, matched it up to Clark Parker, stolen out of Broward County, Florida, and links to not one, not two, not three, but 4 different pieces of evidence from different locations. 2 shell casings from Pappadeaux, 1 round from an autopsy, 1 round from this woman, Cynthia Welch, linked now to 2 murderers in the same vehicle with that very murder weapon. This is a case of overwhelming evidence of guilt. And yeah, I am going to talk about the letter, and you'll have it. It's a letter from Ledbetter to Greene. By the way, despite closing arguments, it was while they were housed together. Remember, they had to go on trial in Cherokee County together and were convicted together there. They call it poison. I agree, it's poison, it's filthy. These aren't my words. These are theirs. Ledbetter to Greene, and if it's poison, note that Greene kept it. Maybe poison to us in what is said, but he kept it. He even says at the top, they read our letters. Look, there it is. They read our letters. You're going to have to pay some consequences, it says further down. Whatever they offer, you need to take it and exonerate me. These are men that are continuing to conspire, even then. And it contains facts. Talk about the restaurant. You got in the car. We went to the restaurant. Went to the hotel. I was smoking a cigarette by the car. You want to talk about malice? With these words. If that lady testified, that's going to F you up. Wow. More heartless words could not have been written. That's why I say don't play with those folks, cuz. You know that lady alive, she going to testify. Murder easy to beat. Murder easy to beat when people did. At the end of the day, she going to testify, and they got both of us. Yes, gentlemen, we do. The state got him. You got him. And you have all the evidence before you that you need to hold these men accountable. Lights. Final kiss goodbye. It'll happen quick. front of him. And then stands over her. As that man crawls to his wife. And she calls to him. Before running for help. Place. Rarely do we have an instance where a person's last moment in life is caught on video. What's most gripping about that is the moments preceding it and that act of love that you saw between Cynthia and Anthony. Cynthia and Anthony Welch did not deserve this. And so I'm going to give you some final thoughts before you go into your deliberations. And the first thing I'll ask you is this. What did you know before we started the trial of the case? All of you said nothing. You didn't know the facts of it. Some of you said, well, I may have heard some media reports, but that doesn't mean I know any facts of it. Remember that? The things that you know about this case, the things that you've seen here now, where did that come from? The evidence, this courtroom, and nowhere else. That's proof as is contemplated by the law. That is proof beyond a reasonable doubt. That thing that you know in your head and heart now, the tough stuff that you had to see here as a juror and as a human being, didn't come from any extrajudicial source. It came from right here in this courtroom for the presentation of the state's case. And I'm glad the defense brought up the weight of the evidence, the sufficiency of the evidence, the burden. I want to talk about it a little bit differently, though, right now, if you'll indulge me as I close out my remarks to you about the case. I want to talk to you about burdens in a little bit of a different way. Maybe I'll talk about a burden that started about a month or so ago at your mailbox. When you opened it up and you got the jury's evidence. And you thought, oh, man, I can't believe it. What an inconvenience. Can't believe I'm going to have to go to court. You get down, you're milling around with everybody downstairs, right? And some people start going, some people don't. They put you in panels or meeting people beside you for the first time. It's like, a day or so, I'm going home. And your number gets called. Time to get in line. We're going up to 6,200. All right, you come in the courtroom. I can see the looks on your faces, right? If it's a drug case or something, I'll come up here to the person. You know, maybe a plea or something, who knows? Who like, right? Who knows? And I watched some of your faces as the indictment was explained to you that first time. Malice murder. Felony murder. And some of you, I know, were thinking, oh, not me. Surely anyone but me, right? We're going to go through this process and ask some questions, find out a little bit about us. But ultimately, it's not going to be me, right? It's going to be somebody else. You can feel that burden kind of ratchet up when your number got called. I know. It's a heavy feeling indeed. This is a difficult thing for you to do. We know that. But let me say this to you, ladies and gentlemen. Don't confuse that weight that you might be feeling, that heaviness that you felt when your number was called, as being something that is not. It's not doubt. It is not doubt at all. That feeling that you feel now and that you felt then is a feeling of compassion. It's the feeling that's the difference between you all and people like Greene and Ledbetter. You have all the tools and all the evidence in the world that you need in this case, and you need nothing else. And had those men exhibited even the slightest feeling that you might be feeling now, none of us would be here today. Make no mistake about it, the choices that these folks made are what put you in this jury box. It's on them. This is their pot of stew that they created, and it is on them. And that feeling that you feel right now, you need to own it and adopt it. Be proud and happy that you have it, because it's what makes you a human being and not capable of doing what you just watched on that video. It's the difference between good and evil. And so, as I close out my remarks, I was thinking about a little anecdote I can share with you. A lot of times people ask me, if we got a cookout or something, they meet me for the day. Ray, what do you do? I said, well, I'm a prosecutor. And they, oh, cool. Can I see your badge? And everybody thinks the badge is cool. And I'm very proud. I'm not trying to belittle it. I'm very, very proud. 18 and a half years, I am extremely proud of my work with the Cobb County District Attorney's Office. I'm proud to work and march alongside men like this, who are tireless in their pursuit of justice. So I have this conversation, and I speak to them, and the first question that people have, can you get me out of the ticket? That's the first way, can you get me out of the ticket? And I go, no, I'm not that kind of prosecutor. I'm the major crimes prosecutor for the DA's office. I head the homicide unit. Wow. So the next part of the conversation, every single time. Yeah, countless times. Wow. Bet you have some cool stories. We do. And then I get this assertion. It must be very frustrating to work in the criminal justice system. And I get it. I mean, only in America can you be caught on video doing a crime like this. Only in America could the geolocation show exactly where you were when it happened. Only in America could forensic science prove that the murder weapon in your possession killed another human being. Only in America can we recover a necklace that you stole during the spree, and you still get to come to court and say not guilty, prove it. I get that frustration that people ask me about. Totally get it. But I will not today and not ever, jump on the bandwagon and say I agree with them. Why? Because while the burden falls on the state and we carry it happily, we do it every single time we walk through this courtroom, we know what our burden is, we know what's required, we know what we have to show you. While it gives them a right to say not guilty, it also gives us a right and an opportunity is to prove what they did. You see, the beautiful part about what's about to happen here is that there's going to be a power shift. As powerful and proud as we might be of our badges, and as powerful as Judge Harris is, she's a remarkable judge, I hope you agree. Suddenly, the most powerful people in this courtroom are seated right here in front of me. With great burdens and great opportunities. And you have the greatest of these today. Because nobody in the entire world can hold the people accountable who did this to Cynthia. Who took this man's life senselessly. Nobody in the world has the power to do that but you. With great burdens come great opportunities. And I'll remind you that you have a duty, a responsibility. You swore an oath. You promised us you could do it. Not that you're going to nitpick, not that you're going to look at things, not that you're going to pry stuff together. You will listen to the evidence and you will apply the law. We, the state of Georgia, ask nothing more of you. You've seen the facts. You've seen what we've shown here. You've seen the overwhelming evidence of guilt. And you, ladies and gentlemen, have all the tools that you need to find these defendants guilty. It's what the facts have shown. It's what the law requires. And it is what justice demands.
All right, ladies and gentlemen, we've been sitting for a long time this morning, and it's going to take me a while to give you the charge of the court, the law that you need to apply. And so I think for a variety of reasons, we're going to go ahead and take the lunch break now. It's about 12:15. I'm going to ask that you be back in the jury assembly room at, let me ask you to be back in the jury assembly room downstairs at 1:45. Y'all are going to be on your own for an hour and a half to go and eat wherever you would like to. Please be on time back downstairs. And let me remind you, while you have heard all of the evidence in the case, and you have heard the arguments of the lawyers, and they all argued very well, you still don't have the law from me. And you have not been given over to the jury room to work on a decision. So the case is not with you yet. So that means two things. One, it means keep an open mind still because you don't have a law. And the second thing it means is you are still not permitted to discuss the case amongst even yourselves, okay? Not what you think of the lawyers or their arguments or the evidence or anything. You're not permitted to discuss it amongst yourselves. And it also, of course, the rule still holds now more than ever. Don't get on social media and talk to anybody else about it. Don't use Google or anything else. Just because you've heard all the evidence doesn't mean that you can go out and start looking at your own evidence, like maps or anything else like that, all right? So please stay off of social media about this case. I know there's been a little bit of, there was a request this morning for media coverage. I don't know if there'll be anything on the noon news, but you're about to hit the noon news cycle. Please do not watch anything, listen to anything, live stream anything. As soon as you hear something about Cobb County courtroom, if you do, please turn it off, all right? Are those instructions sufficient for the lunch break?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, so go and enjoy your lunch, and we'll see you back at 1:45. If I can ask the lawyers, one reason I want to give a nice longish break, first to give y'all a chance to unwind, because I know it's been an incredibly long, stressful week and a half, and y'all have worked very hard diligently. But I also thought perhaps before 1:45, if y'all have a chance, if you haven't already figured out what goes out, what stays in terms of what goes out with the jury, that might be helpful if we don't have to delay them getting the case. But if y'all don't have time to do that before 1:45, I understand.
That's no problem, Judge. Why don't I work on getting a stack together what I think doesn't go out, and then if you guys want to eat first and come look at it, or
That sounds good. Yeah.
Okay.
or
I mean, that's
you look
fine,
at
or
it.
I can stay, whichever you would prefer.
And I don't want anybody to skip lunch. I mean, if you can't do it before 1:45, I'm fine. I just thought that was one of the reasons why I left it a full hour and a half.
Tell you what, I'm gonna go eat first. I'll come back early and I'll start doing that.
Will the deputies be around so that they can get in the courtroom? Oh, you know what, hang on. If everybody's gonna go eat, that's great. That'll give Ms. Lawrence, because obviously she has to be here. So actually,
Can I make one suggestion?
yeah.
Since there is so much evidence, I can make them copies of my list, if that will help. Would that help anybody go through?
That'd be great. That would be very helpful. Thank you.
Yeah, I can do that. Make copies of the
Okay,
list.
I'll tell you
They can
what,
go
let
through
Ms.
it.
Lawrence make, can you make 3 copies of your
Yes.
list? And then you need time to eat, Ms. Lawrence.
Yes.
Do you wanna, what time is good for you to be back, like
Whenever.
1:15?
I'm not going nowhere, so it's fine. Whenever's fine with me.
Oh, that's crazy. How about